The state needs sufficient funding to clean up both well sites and non-well sites. We need sufficient assurance bonding and the reclamation fund. I do feel that one point made by industry is fair. I hope your rules will ensure that plugged wells are inspected promptly and bonds are released promptly after the inspection passes. But I implore you to pass responsible energy policy, protect our land health and future and financial stability, increase the bonding requirements, especially the egregiously small blanket bonding requirement, so New Mexico has the resources to clean up abandoned oil and gas sites. Thank you.
Thank you, Mr. Weichel. I don't see anyone else in the room at this time. Let's turn to the platform. Let's see. We have Natalie Summer, I believe. Ms. Summer, can you unmute yourself?
Yes, I'm here.
Hello. Would
Hello.
you spell your first and last name, please?
Yes, Natalie, Natalie, Summer, Sommer.
Do you swear or affirm to tell the truth?
Yes.
Thank you. I'll start your time.
Thank you. Good afternoon, commissioners. Thank you for the opportunity to speak today and share my perspective. My name is Natalie, and I'm a lifelong resident of New Mexico. I've spent a significant portion of my life recreating in the diverse landscapes of southeastern New Mexico, where much of our state's oil and gas production takes place. I know how special this region is. The Permian Basin's desert trails, grassland habitats, and vast network of limestone caves form a place where geology, history, and human experience meet, and it deserves protection equal to its value. That's why I support stronger oil and gas bonding rules to ensure corporations, not taxpayers, bear the cost of cleaning up after drilling. Right now, New Mexico faces an estimated $700 million to $1.6 billion in potential well cleanup costs because current bonding levels are far too low, covering only a small fraction of real cleanup expenses. Wells left unplugged make our communities vulnerable to pollution, degrade the lands and waters that define our identity as New Mexicans, and leave our taxpayers responsible for the bill. The Permian Basin isn't just an oil field. It's also home to Carlsbad Caverns National Park, Sitting Bull Falls, and Pecos River Valley, all of which draw hundreds of thousands of visitors each year. When wells leak or landscapes are scarred by neglect, it doesn't just harm wildlife and water quality. It harms local economies built on clean air, clear skies, and natural beauty. New Mexico has already shown innovative leadership through the Taxation and Revenue Department's award-winning oil and gas compliance tool, which has been recognized nationally for improving data transparency and accountability. Strengthening bonding rules complements this investment. It ensures our commitment to responsibility extends beyond production tracking to full cleanup, aligning with the state's values of fairness and fiscal prudence. If you drill, you clean it. That seems like common sense and basic fairness. Every responsible business pays the true cost of operating, from insurance to safety compliance. Oil and gas shouldn't be different. Bonding for cleanup isn't a burden, it's accountability. It's simply part of doing business responsibly. I urge the Oil Conservation Commission to adopt strong, modern bonding rules that protect our public lands, our health, and the future of New Mexico's people and economy. Thank you.
Thank you, Ms. Summer. Is there anyone else on the platform who'd like to offer public comment in this session? Our next public comment session will be 9 a.m. on Monday. If you can, raise your virtual hand. If you have dialed in on a phone, you can raise your virtual hand by pressing *5. All right, in that case, thank you. We will return to Mr. Sharp and his questioning. There you are.
I'm here.
Thank you very much, Mr. Sharp. Let's see. Where did I believe it's Mr. Tremaine, yes?
I believe it's where we're at, Madam Hearing Officer. Thank you.
Thank you.
Good afternoon, Mr. Sharp. My name is Jesse Tremaine. I am the Legal Director for the Oil Conservation Division. I do have a couple questions for you today.
Thank you. For sure.
All right. Mr. Sharp, did you hear Mr. Powell's testimony and rebuttal and rebuttal testimony the other day?
I did not.
You did not? Okay. At the beginning of your testimony, you addressed the confusing or conflicting definitions of marginal wells, which you used in preparing your direct, and appropriately adjusted your testimony and your assessment of marginal wells, correct?
Yes.
Okay, so by your assessment and your revised testimony today, Marion has 2 wells which would fall into the proposed definition of marginal well category, correct?
Yes.
Okay, I just want to be clear here because yet after that revision, when offering your conclusions, you showed a slide and reiterated a $945,000 annual impact to Marion, correct?
For the bonding, no, I didn't show the slide. And Ms. Tripp may have had it. Ms. Tripp may have
Mr.
had
Tremaine,
it.
I believe we can amend those demonstratives or strike them. We're not.
I'll just ask a clarifying question. So Mr. Sharp, if with your revised understanding of the marginal well category and just determining that you have 2 wells in marginal well status, would you agree that Marion, if at the time that rule went into effect, Marion would have to provide $300,000 in financial assurance?
That is my understanding
Okay.
based on the latest conversations.
Okay, but that won't happen until 2028, correct?
That is also my understanding.
Okay, I want to ask you just a couple questions because you responded to some rebuttal comments and testimony about the Farm C COM, and I believe you had indicated that well had been plugged back to the Fruitland coal, correct?
Yeah, I believe both the Fruitland and the PC have been completed in it. And
Okay.
are commingled right now.
And then you indicated that your Marion's plan was to go in and drill out and do a workover on that well. Is that correct?
That is the plan.
And how much do you expect that drilling out and working over that well to cost?
I don't have an analysis of that. If I were to make a guess, I would think we could get it done for less than $100,000.
Okay, so to plan for drilling out the plug and work over, you reasonably have to expect the well to make money after performing that work, correct?
Yes.
So is it your testimony today that after drilling out that plug and performing a workover, that you would reasonably expect that well would be unable to produce for more than 180 days per year?
No, I think it'll be on production virtually all the time once we drill out and get it on. The Dakota, when we abandoned that zone and for the uphill recompletion, was making 50 to 60 MCF a day, and that is economic.
So based on your workover plans and reasonable projections, once that's completed, that well would no longer fall into the marginal well proposed definition, would it?
That's our hope.
Thank you. So you talked about the impacts of financial assurance. Are you, and we just clarified the $300,000 financial assurance impact that would hit Marion in 2028. Are you testifying today that the premiums on $300,000 in additional FA in 2028 will be a hardship for Marion?
It'll be a hardship for those wells and the owners in those wells. I mean, the wells have to pay the cost of it, and it's going to be a significant increase in the operating expense of those wells, over $1,000 a month.
Okay. But so that's a no as to Marion as a whole.
As a whole, we can afford the $300,000. Marion Oil and Gas is not in debt. And so we have, some horsepower left, and can deal with that obligation. It was my direct testimony that there are a number of operators who won't be able to do that, that are either carrying debt, and their only way they're going to come up with more money is to borrow it, and that those other many of those operators are going to walk away, and this rule is going to backfire, and it's going to dump.
All right. Well, Mr. Sharp, I'm asking you about my question to you is about Marion. So I'll let those other operators testify on their own. You talked about the force plugged M&M well. I just want to ask you, do you dispute that if Marion is quote unquote force plugging another operator's well, that means that at least one regulatory entity had to pursue an enforcement action related to the well?
I would say yes. The BLM pursued an enforcement action.
Okay. Another question on that. I believe you had indicated that Marion was a 50% record title holder in that well. Is it common in record title arrangements that record title holders receive benefits from production and development of wells in which they hold record title?
No, not in it. No. Operating rights, actually own the wells and drill the wells. We, on that lease, we never did own the PC rights, which is, I believe that's a PC well. Our operating rights are only as to from the base of the PC to the base of the Dakota, and on that lease. And so, but record title is not depth segregated, at least with the BLM. And so we had no economic benefit in that well.
Thank you for that. Mr. Sharp, do you agree that, as an operator, Marion, that production reporting is an important requirement for operators in New Mexico?
Sure.
And a failure to report production is a violation of OCD rules, correct?
I would assume.
And a lack of production reporting occurring for over a year means a well is inactive, correct?
I would assume.
Would you dispute that, according to the most liberal interpretation of Exhibit 16, there are 599 separate O-grids that have at least one registered well associated with them?
I can't speak to that.
Okay. Would you dispute from OCD Sir Rebuttal Exhibit number 3 that there are 113 operators who have not reported any production since August of 2024?
Again, I cannot speak to that. I really didn't listen to the that testimony or see those exhibits.
Okay, thank you. Would you dispute my math that 113 of 599 is a little shy of 19%?
Sounds like good math to me.
All right. You made a statement during your testimony that orphan wells and noncompliance is concentrated in a small number of bad actors. Is that an accurate statement?
That is an accurate statement.
Okay. If 113 operators, or approaching 19% of operators, have portfolios which have failed to produce or failed to report production in well over a year, and are out of compliance as inactive wells, would you maintain that statement that orphan wells are a problem of a few select bad actors?
Well, those wells have not been orphaned yet. They have not been left to the state. Those operators are still. I'm assuming that the operators on the orphan well list that OCD provided I couldn't find most of those operators in Empress. I mean, and most of them I've never heard of, and you know, they went away so long ago that they don't even show up in the public databases. And so, in terms of the you know, the orphaned wells, and just because wells, you know, production hadn't been reported doesn't mean that well has been orphaned. You know, again, I maintain that most operators, as your statistics demonstrated, are prudent operators, and even the ones that may not have reported production. I think many of those still have, you know, they haven't abandoned, they haven't walked away from, you know, from all their wells. Now, again, in my direct, one of my contention is as soon as you put this bonding requirement on those 130.
Well, Mr. Sharp, I'm not asking you about that. I'm asking you about your assertions that the orphan well problem is attributed to a very small percentage of bad actors. So are you testifying to the commission today that the almost 19% of operators who have not reported production in over a year, which means their portfolios are 100% inactive and have to be plugged pursuant to 19.15.25.8, are not of a concern of becoming orphaned?
Well, hit them with a $150,000 bond, and they're darn sure going to become orphaned.
I'll pass the witness. Thank you.
All right, thank you, Mr. Tremaine. Mr. Biernoff?
Thank you, Madam Hearing Officer. Good afternoon, Mr. Sharp. Ari Biernoff. I'm a lawyer for the New Mexico State Land Office and the Commissioner of Public Lands. Let's talk a little bit more about the plugging that Marion undertook that you described in your direct testimony and reviewed a little bit with Mr. Tremaine just now. Do I have this right? Marion was one of the record title holders of a lease, and there was a well on that acreage operated by M&M. So far, so good?
Yep. Yes, sir.
Okay. And why was it that Marion was called upon to plug that well?
Because once the operator goes away, and M&M went bankrupt, then the BLM goes to record title to require them to address that issue. We're still in the food chain in terms of liability.
Okay. M&M went bankrupt. Do you have any idea of how many wells M&M operated at the time that it went bankrupt?
I don't, but they are in your, M&M is in the OCD list of orphaned wells.
Was M&M?
I can't give you a number on that. Hang on just a sec.
Oh, okay. Yeah, if you have it accessible, I'd be happy to hear it.
All I know is that let's see. I'm sorry. This is taking just a sec. Why don't you go on with your questions, and I'll try to hunt it down while I'm doing this.
That's fine. Thank you, Mr. Sharp. Did Marion plug any other wells that were operated by M&M that were on Marion lease acreage other than the one that you've talked about?
That is the only one that that Marion has been affected by. We don't own any. We did own the deep rights, but I think those have been sold. We own no operating rights in that lease, but yet we own the record title. So one of our practices when we convey wells from now on is to try to make sure that record title goes with it, so we're not left holding the bag.
Understood. And the state system is similar in that regard to BLM. has Marion plugged other wells that were operated by other companies aside from M&M?
This is the first I'm aware of.
Okay. Would you consider M&M to be a bad operator or a non-compliant operator?
They're gone. They must be. They couldn't have been a very good operator.
Do you know what happened to the owner of M&M?
I have no idea.
Okay.
We actually tried to buy a bunch of their production a while back, or 20 years ago, and we're not successful in being able to do that. But I've never really dealt with them directly. I dealt through an intermediary.
Okay. Would it be useful for a company, for your company, for Marion, in instances where you're called upon as the record title holder to plug a non-compliant operator's wells, to have access to any bonds that that bad operator had on file with the relevant regulatory agency?
It would absolutely be helpful to have access to the bonds, but we do not. And under the current rule, or at least the way the current bonds are being done, we wouldn't have, even if they had a $150,000 bond on there, you don't get access to that money until you plug the well. And so you've got to plug and fan the well, which is a 2-3 year process, to get a fan before that bond is released. And so that's the other irony here, is that the operator's got to come up with the money twice. They got to bond it, then they got to plug the well, and then wait for their bond to be released. And
well, I appreciate the additional detail, but my question was pretty narrow. It was whether it would be beneficial for Marion to have access, in this example, to M&M's bonds if there was one.
If the rules could allow that, allow access to the bond money to plug the wells while you're plugging the wells, that would be awesome.
Okay. Thank you very much, Mr. Sharp.
Thank you, Mr. Biernoff. Let's see, we don't have Ms. Nanasi. Mr. Maxwell, do you have questions of Mr. Sharp? Oh,
No
yeah.
questions. Thank you.
Thank you. Mr. Rankin?
No questions.
All right,
Thank you very
thank
much.
you. EOG is monitoring. Mr. Suazo?
No questions for this witness.
All right, and Ms. Tripp, do you have any redirect?
Very briefly, Madam Hearing Officer, just because there were a couple numbers thrown around, and I want to make sure that the record's clear. So, Mr. Sharp, I think we've established that that Marion has 2 marginal wells that qualify as marginal under the proposed rules. Is that right?
Yes.
Okay. And the part of the testimony which I'm showing you, that most of the wells we operate make only $10,000 to $20,000 per year in profit. Any changes to that part of your testimony?
No, 65% of our wells make less than $15,000 a year.
And so to the extent we also talked about, so that's $300,000 in financial assurance for those 2 wells. Marion is cash bonded. So even if there was a 10% premium, you're not paying $15,000 a year on those wells. What does Marion have to do to put a cash bond down?
Take money out of one account and put it in one you can't touch. And so we've chose to do that. Marion is lucky enough to have the cash to be able to do that. Let me say that. And but nonetheless, that money is out of circulation. The cost of that money, and there is a cost to not having access to your money. That is will affect the economics of those wells.
And the amount of that money we're talking about is not $15,000 per well. We're talking about $150,000 in cash that's set aside. So total effect, if this rule was implemented, would be that Marion would need to post 2 separate $150,000 bonds, which would remove $300,000 of capital from that you would otherwise allocate. Is that correct?
That's my understanding.
Okay, thank you. And then you were asked a little bit about the percentage of operators. And the way you understand the rules, even if there are 20%, we'll call them bad actors in quotes, does the rule only target that 20%, or does the rule also affect the 80% of responsible operators who plug their wells?
It affects everybody.
Okay.
100% of the operators.
Thank you. No further questions, Madam Hearing Officer. And actually,
Thank you.
we will proffer, I forgot to proffer Mr. Hannigan's rebuttal testimony and then Mr. Sharp's direct testimony.
I'll pause in the event there are objections. All right, thank you. They're admitted. Commissioner Ampoma, do you have questions?
No, I do not. Thank you.
Commissioner Bloom?
No questions, Madam Hearing Officer. Mr. Sharp, thank you for your time today.
Chair
Thank you all.
Chang?
Thank you all for the opportunity.
Hold on one second.
No questions from me either, so thank you.
Okay. Thank you, Mr. Chair. If there's no reason not to excuse Mr. Sharp, thank you very much, Mr. Sharp.
My wife says there's several reasons not to excuse me, but thank you. I will take my leave.
All righty, so we're going to recess here for the weekend and I'll see you
Madam
back.
Hearing
Oh,
Officer, just
Mr.
one
Cloutier.
thing.
Yeah.
I'm not able to keep up with the emails. Mr. Gilstrip may be unavailable first thing Monday morning, and if that's the case, we'll switch him and Mr. Winchester in order, but I'll let everybody know over the weekend when I get it sorted out.
Thank you very much for that, Mr. Cloutier. So thank you all. Have a great weekend. Happy Halloween, and we'll see you Monday at 9 a.m.